All right, you're charged with a terroristic threat of a public servant or placing the public in fear of serious bodily injury.
This man is moments away from pleading no contest to a charge of terroristic threat. He believes the deal will spare him prison time, giving him the chance to reunite with his son. On paper, the agreement looks straightforward until the judge uncovers a buried detail in a court document. It's a protective order from a separate case, holding a cryptic list of names. One line in that document changes everything. Even his own lawyer never saw it coming. What happens next will unravel the plea deal in real time and leave everyone wondering, was it a simple clerical error or a carefully placed trap?
Calling 2025 CR 007563, State versus Ronald Allen. Can I have parties announced?
Lauren Smith, State.
Charles W. Booker for the accused. Ronald Allen.
All right. Counsel, you received all discovery?
Yes, I did, Judge.
And did you review that with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Allen, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes, I did.
Did you understand it and sign it?
Yes, I did.
Did you review the true bill of indictment with your attorney?
Yes, I did.
Did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Allen, did you review the court admonishments and waivers with your attorney?
I did.
Did you understand it and sign it in all the appropriate places?
I did. I did.
All right, you're charged with a terroristic threat of a public servant or placing the public in fear of serious bodily injury as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to the $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I do.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea you were giving up those rights?
I do.
Did you intend to give up those rights and enter into a plea in this case?
I do.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
I understand.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Allen, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I have.
Are you a U.S. citizen? I'm sorry, not a U.S. citizen. That's not allowed to be asked anymore. Did you understand by entering in this plea, you could, if you're not a citizen, you could be deported, not allowed to re-enter the United States or denied naturalization. Did you understand?
I do.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Yeah, he can appear by his own. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. State is silent on your application for deferred adjudication. The state recommends community supervision. Did you understand that to be the plea?
I do.
Defense?
Yes, that's true.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do understand.
And counsel, I believe we had any pretrial motions?
We did have some trial motions previously in this case, and they've been disposed of.
All right. Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, no contact with Charles Allen or Mark Medley. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I understand.
And there it is, the first clue. The state insists Ronald have no contact with two men, Charles Allen and Mark Medley. That answers our first mystery, but instantly sparks a bigger one. Who are these men? And why are their names tied to a terroristic threat case born out of a custody dispute? The story just widened, and it's far more complicated than it first appeared.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor, state tenders, what has been marked State's Exhibit 1 and all attachments.
All right, did you review any objections?
I have no objections to those pieces, Judge.
Mr. Allen, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
All right, anything you wish to say on behalf of your client?
Yes, Judge. Last night, I electronically filed a sentencing memorandum. I think it's been accepted by the court, and I wanted to provide it to you along with the attachments.
All right, any objections to the court reviewing the? Okay. All right, yes.
And so, Judge, as you can see, essentially what primary reason and the desire for Mr. Allen is that he be able to continue with supervised access to his son, Aiden. As you can see in the attachments there, the civil trial court did understand that Mr. Allen would have supervised access to his son, both in San Antonio as well as North Texas. Additionally, we do know that on the 22nd, we received a letter from Thomas Villalobos, an update letter regarding bond conditions. That letter also attached had the Center for Healthcare Services finding that they had met with Ronald Allen to complete an intake for mental health services and that he hadn't met criteria for qualifying mental health diagnoses at that time. The largest thing that matters the most to Mr. Allen and his family is that his GPS permit him to be monitored. That's fine if that's what the court desires, but he would like to be able to move freely about the state, to be able to see his son from time to time, attend his father's services, and help his mother maintain his father's properties. And so that is the primary thing. We totally agree with no contact with either Michael Ireland or Mark Medley. That's new to me, but he's fine not staying away from that man too.
Based upon the judge's notes that you presented to the court, those are people that are listed under the protective order.
This is the turning point, the moment everything hangs in the balance. The judge spots a protective order that seems to list Ronald's own lawyer as a protected party. Instead of clarity, the document unleashes chaos. Now the judge suspects a hidden danger no one disclosed. And in an instant, Ronald's credibility isn't just questioned, it's on trial.